our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I'm blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, and welcome to the show. Today, we're talking about investor legislative update. We're looking at up-and-coming laws that you as a real estate investor should be aware of, know about, and be ready for. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel and subscribe. Helps us out a ton. You can find us on YouTube, Facebook, or X, and you can find us at the handle @InRem Podcast. That's @InRem Podcast. Also, if you don't have time to watch it, but you just want to download an audio version, that's easy to do as well. You go to Apple Podcasts, Spotify, or one of the other major platforms. Download it for free. Super easy. Leave us a review. We'd appreciate it. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So our legal update actually is a good segue into our show today, which is legislative update. But today I'm not talking so much about legislation as I am a rule, and it's an administrative rule passed by or implemented by the FTC. So the FTC has implemented a rule on employers that basically prohibit non-compete agreements for employees of employers. So basically an employer cannot require non-compete agreements with some exceptions, which we're going to talk about. So basically what the rule says is that employers cannot enter into a non-compete clause with an employee. They cannot enforce a non-compete clause that an employee would otherwise be subjected to. So let's say that the non-compete was entered into a few years back before the rule. It doesn't matter. The employer is barred from enforcing the non-compete provision. What is a non-compete provision or non-compete clause? And so the FTC has defined that as well. So it basically, a non-compete provision or clause is any clause seeking or prohibiting an employee from seeking or accepting work in the United States with a different employer after the conclusion of employment, or operating a business in the United States after the conclusion of employment. So basically what the rule is saying is, hey, look, employer, you cannot draft or seek to enforce any non-compete agreement. And a non-compete agreement would prohibit an employee from going and working at a competing business or opening their own competing business after their employment is over. Now, the rule is not without exception. There are a number of exceptions with the rule. So the first is that the rule does not prohibit non-competes that last during the employee's employment, which is actually very consistent with state law. Most states prohibit employees from competing with employers while they're employed. I mean, it's case law to that effect that says basically employees owe that duty to their employers not to compete while they're employed. They can prepare to compete, but they cannot compete while they are on the payroll. The second is non-competes arising out of a sale of a business is not prohibited. So, you know, you go in to buy Judy's candy shop and you say, okay, I'm going to buy your candy shop, but Judy, I don't want you going down the street and opening a competing candy shop. And that is allowed because, there is certain levels of equal, bargaining power, negotiating power. And it also makes sense. Why would you buy a business just to have that same business owner open up a competing identical shop or similar shop down the street from you? So you can have a non-compete for the sale of business. And then finally, non-competes are allowed for senior executives who are defined as those in a policy-making position and who received total compensation of at least $151,164 in the preceding year. So senior level employees who basically make policy decisions for the company and meet that certain minimum income requirement, they can have non-competes within their employment documents. Also, the rule is silent on non-solicitation clauses and confidentiality agreements. So presumably those documents are enforceable as long as they meet the requirements of state law. So a non-solicitation agreement would say, well, you may have access to our clients, our vendors, our customers, our other people that are vital to our business, even employees, current employees. You can't go and take those from us. You can't solicit those and remove them from us or make it so that we can't continue to do business with those individuals or companies. And then also confidentiality agreements. I as an employer might provide you with sensitive data. For example, law firms, employees have access to client information and documents and things like that. And so confidentiality agreements are an important aspect of many businesses and are important. And those are going to presumably be enforced because the rule doesn't prohibit them. And so those will remain in place. Now, this rule is not without court challenges at this point. So there have been 3 lawsuits filed challenging the constitutionality, 2 cases in Texas and 1 in Pennsylvania. So we'll see how it makes its way through the court system. But we do have this rule that was propounded by the FTC, which does ban non-competes for employees.
All right. Thank you, Sean, for the legal update. With that, a couple of announcements. Make sure to join us today at 2 p.m. and every Tuesday at 2 p.m. Arizona time. That's 2 p.m. Arizona time for the Creative Finance Collective. What is that? That's an opportunity for professionals in the space of creative finance to get together, mainly lawyers, to talk about the laws of creative finance, what we're seeing in different states, what we can do to make each other's forms and practice better. It really is kind of a niche group of professionals, not a lot out there, not a lot of attorneys out there anyway, that brand themselves or spend a lot of time understanding the nuances of creative finance. So if that's an area of interest to you, this is really a valuable time for you, because not only do we discuss creative finance, but we make ourselves available to you, the listener, for the entirety of an hour to answer any questions that you have. So this is a time for you to engage for free, I might add, with professionals in the space to talk about creative finance and get your questions answered. We're there as long as we're getting questions. And for weeks now, we've had a lot of good dialogue. So make sure to be a part of it. We'd look forward to seeing you and having you there. Also, for today's episode, if you have questions, we're going to try to get to answering any questions that you might have in the final 15 minutes of the episode. So what does that mean for you? Don't wait until the final 15 minutes to ask your question. Go ahead and post the question in the comments. We are monitoring that, and we will get to those questions in the final 15. So if you got a question, go ahead and post it while you're thinking about it now. All right, so today our topic is investor legislative update. We wanted to talk about legislation that has been passed or is up for consideration to be passed that may impact or have some sort of impact on you as a real estate owner or a real estate investor. And with us to discuss that topic is our old friend, Jeff Watson. Jeff, thanks so much for joining us.
My pleasure. Good to be here. Can you hear me clearly?
Yeah, we can hear you and see you clearly. Appreciate you being with us, Jeff. You're a lawyer with the Jeffery S. law firm out of Ohio. Tell us about that law firm and what you guys focus on.
Well, it's a solo practitioner set up as an LLC with one amazing assistant, without which I would be completely, totally lost and confused. It's becoming more and more a technology company wrapped around a law firm. With different advances, it lets me be a lot more mobile, and so I am pretty much out of the courtroom completely. I've got a couple of cases left, and you've got to be a really good client to induce me to go back into the courtroom. I'm just saying, because I got 30 years of trial work and I'm done doing that stuff. But anyhow, a lot of what I love to do now is in the self-directed IRA space. The private lending overlaps with self-directed IRA. Creative finance overlaps with self-directed IRA. So that's predominantly a lot of what I do. The other two things that I do is I educate and I advocate or I lobby. For a dozen years now, I've been doing lobbying work on Capitol Hill in Washington, D.C. We've had a few big wins, one big massive win, and we just keep pushing these rocks up the hill. And I've done some stuff in the Ohio State House that's influenced a number of other states on one of the topics we're going to talk about today. Ohio was a trendsetter on a very interesting issue. Some people think it's a little controversial, but I think we've set the standard in Ohio, and I was privileged to be able to help set that standard. That's, as we'll see, is pretty much becoming codified law in a lot of other states now.
Well, Jeff, we know that you out of a lot of the guests that we've had the pleasure of talking with and working with, we know that you're a pretty tapped in guy when it comes to legislation, both at the state level and at the federal level. So we knew when we thought of this topic, you were our guy to go to on this. So
thank you.
Let's start with one of the top here, and we kind of circulated this to find out, hey, what is some of the best legislation our listeners need to know about? And the first one that came up that we want to talk about, the Affordable Homeownership Access Act, HR 3464. Why don't you give us kind of the purpose of that act and kind of the skinny behind it?
Sure. And I mean, I can go for an hour about this bill because this has been something that we have been now working on. This is our 5th session of Congress that we're pushing this on. This started with a group of guys out of Texas, Houston and Dallas, that were looking at Dodd-Frank and how it restricted seller financing and limited a owner of real estate to only doing 3 seller finance transactions in a 12-month period of time. And we looked at it and we said, this is unconscionable. We can't live with this. We need to change this. And so we have had different versions of this bill pending at different sessions of Congress. And the current version, the Affordable Homeownership Access Act, seeks to amend just one tiny fragment of this massive, horrible bill called Dodd-Frank, and this thing called the SAFE Act, and this other thing called Truth in Lending. And we're reaching in there and we're grabbing this little number 3 and we're turning the dial all the way over to 24. And then we're coming back out without changing anything else. And you would think that in the land of the free, the home of the brave, where capitalism is still somewhat recognized, that there wouldn't be a single person that opposes that idea. But you would be wrong. You would be very wrong. There are people in power, in state, and particularly in federal government, that do not think that you should be able to do with your property as you see fit. And so the whole idea, guys, is we want to increase the number of seller finance transactions an owner of a property. This is somebody who either it's a longtime landlord. They've accumulated a portfolio of 40 houses. Now they want to sell. They want to turn them into notes. They know how to underwrite a deal. Under Dodd-Frank, they would take them 14 years to do that. If we can get the bill passed, they could do it in 2.
Well, let's break this down a little bit. So right now, we have Dodd-Frank, the SAFE Act, Truth in Lending. As I understand it, there are 2 exceptions out there for Dodd-Frank, one being a property owned by an individual. And
Correct.
they're only going to do one of these transactions, I think, in a 12-month period. And they can basically do, for lack of a better term, whatever they want. There's really not much, but there's not much restriction on them.
Yeah.
You know, they don't have to do any type of reasonable qualification determination. They don't have to, the loan terms aren't as restrictive. But then there's this second category, which applies to properties owned not by individuals, but by entities. And it allows entities or entities with common ownership, I think is the way it's been interpreted, to do up to 3 a year. But there are restrictions on the financing terms that maybe won't be applied to like the individual doing it. But after 3, like they have to go through and underwrite it through a RMLO, or just not do it at all. So talk to us a little bit about that. That's the exception you're getting at, right? That's right. What you're trying to change. Talk to us a little bit about that exception and, you know, what the restrictions are right now and what you're looking to change.
So, okay. So what we're looking to do is we're looking to take that second exception you described, we're looking to take it from 3 to 24. Because selling one house a year just is it's just worthless. And I mean, you know, if you're an individual, you're doing one a year, the only real special thing you're allowed to do is you can put a balloon term in the note after the 60th month. If you're doing 3 as an entity, you can't put any balloon terms in there. But here's what we tell the legislatures and, you know, the staffers and everybody else and the committee staff and so on. And I don't think, I'm just doing a little bunny trail. I don't think people realize just how much power committee staff has. They make or break a piece of legislation. But what we tell them is, listen, we're not trying to change any of the consumer protections. We're not trying to change anything here. We're not putting any risk on the government. We're not asking for any federal backstop, any government backstop. We simply want to be able to sell our own houses the way we want to. And we want to do more than 3 transactions in a year. And we are aware, very aware, that we must document that buyer's ability to pay. We need to document it. And I'm going to tell you, there's 2 reasons why. If you're listening to this and you're like, well, why do I need to do that? You need to do it for 2 reasons. Number one, you need to prove that they can actually afford the property so that you're not going to be sweating whether or not they're going to make the payments. Secondly is, what if you want to sell that note 10 years from now, 5 years from now? What if you want to sell either partial or whatever? You better have a really good underwriting file that shows that at the time that you did this, they had the ability to pay. Yes, the payment history is going to matter, but you want to see the whole thing so you can get the best price for that note. And the key is, and the fundamental key is, as I tell member of Congress after member of Congress, it's our capital. Please let us prudently risk it in the way we see fit. We're not asking to take advantage of consumers. These are not high cost loans. These are not predatory in any way, because if something goes wrong, I get hurt, nobody else.
So if this legislation were to pass, and looking at that investor group that, you know, the exception would apply to up to 24 in a 12-month period, what restrictions will still remain on their, you know, loan terms?
They still have to follow everything else. They still have to verify and document the ability to pay. They can't put in balloon terms. Mm-hmm. They have to do a straight amortizing loan, 15, 20, 30-year full payoff. They can't do anything funky. They can't do any of these alt option, flex arms, whatever. We can't do any of that stuff. Keep it simple. Keep it super simple. But what we can do is we can now do 24 of these transactions in a rolling 12-month period of time instead of 3. And for about 80% of the seller finance people out there, being able to go from 3 to 24 just completely removes the roadblocks out of their way. But the other really important public policy thing that this does is this makes additional capital available to otherwise unbankable home buyers. Because right now, what we look at the home buying availability, it is 48% of what was available before the virus, before COVID. So only 48 out of 100 people, 100 before COVID, 100 people could buy a house. Today, only 48 of those 100 are now bankable.
Mm.
So we're saying, let us sell to these other 52. They've got decent credit. They've got good jobs. They've got a good down payment. They're good people who want a good home in a good neighborhood. Let them sell it to them, and don't let us hold back at 3 apiece.
And to be clear, and you're talking about home buyers, and in particular, these the current legislation and even the proposed legislation would be targeted to the sale of residential properties to an individual who intends to reside in the property, correct?
Correct.
Okay.
Absolutely. See, there is no Dodd-Frank restriction on a non-consumer, non-residential property. I can sell a whole portfolio off, whether it's 4 houses or 400 houses. Dodd-Frank doesn't apply. But when I'm dealing with an end user buyer, owner occupant, that's when Dodd-Frank applies, and that's why we need this exception. And it would literally, the passage of this bill would literally open up hundreds of millions of dollars of additional capital and opportunity for people to become home buyers.
Now, do you think that there are a lot of investors out there that are sitting on the sidelines and not doing these types of transactions because of concern over Dodd-Frank and the SAFE Act?
The data tells us yes.
Okay.
When we look at the data, we see that over the last dozen years, the frequency and volume of seller financing has rapidly slowed down. Now, someone could say, well, Jeff, I can get so much cheaper money at the bank. Well, wait a second. If that was the case, we would have not seen the credit availability index keep shrinking. So even before rates skyrocketed, we were seeing, before they skyrocketed rates after the pandemic, we were seeing this very narrow buy box that banks would fund people at. And so we knew that it was not just interest rate sensitive. We knew it was a bunch of other factors. I'm going to give you an example, and this is, this is me practicing something. I've got to go up against a group of mortgage bankers. These are the people who are standing in the way of our getting our bill moved through committee. And I want them to defend the conscionability of a $100,000 sale price on a small 3-bedroom, 1.5 bath home in my hometown, where the buyer had to pay over $7,000 in fees to the lender for that $100,000 loan. Defend that for me, banker. You can't. You robbed somebody. Seller financing, I would have I wouldn't have had that issue.
And what's interesting on seller financing is, like you were saying, it's maybe a tired landlord or somebody like that who they want the cash flow every month.
And they not only want the cash flow every month, but they want to take advantage of the Installment Sale Act that the IRS has had on the books for over 50 years.
Mm-hmm.
We want to be able to plan out. I mean, to me, it's mind-boggling. I look at it and I go, Mr. Member of Congress, Ms. Member of Congress, the IRS says we can do this. Why won't you let us do it?
Mm-hmm. Yeah.
If you're worried about, if it's not about money, it's not about revenue, it's about you want to control.
Right.
You want to strangle private ethical capitalism.
Well, and I've also seen it in my practice where I have clients who are, whether commercial or otherwise, they're doing, these types of transactions. And one of the analysis that they have is, okay, I want the cash flow, and I do not want to do this transaction and have interest rates go down in the next 2 years, only to have them pay my principal balance back. And then I don't have the cash flow coming in anymore. And so they actually not everyone, right? I mean, I'm not making a generalization, but there are some savvy investors who look at the interest rates and say, I'm actually going to go lower than what the bank can provide, because otherwise, if I go too high, when they do become able to qualify for, conventional financing, they're just going to refinance me out. I'm going to be done. I'm going to lose the cash flow. So they actually try to figure out, okay, how can I hold on to this the longest and make the greatest return? And so their financing is actually better in many times than what you can get out on the open market.
Correct. Their financing is better because they're keeping the rate with that in mind. They're not charging for PMI.
Mm-hmm.
And they don't have every fee that you can think of, an origination fee, a doc prep fee. They don't have all those fees. There's no poodles running around by the name of Fifi in these deals. We've got it. It's two human beings doing business. And then when I've done these deals and my buyer, you notice I always say buyer, I don't say borrower, because it's an extension of credit. I'm not lending money. That's an important concept to think about. But my buyer, when they run into a layoff or they run into a problem and they reach out and call me, we can work through it. And we've done it on a number of occasions. Can you imagine if that happens with an institutional person? They pick up the phone and the next thing you know, you're routed to a call center in Mumbai or Manila or who knows where. And somebody's reading the script and you have no clue what they're talking about, But instead I get a text message of, hey, Jeff, I just got laid off. I'm not going to be able to make next month's payment. Can we talk? To which I go, yeah, sure. When? And they paid it off. It's all good,
Well, and I've seen that over and over with my investor clients. I've had clients who, before Dodd-Frank were regulations, were doing these types of seller financing. So they have portfolios. And then when the downturn hit, people are not paying their loans, but they don't really want to foreclose. And so they do workouts, and, it's worked out great because, values have rebounded, jobs have come back, the whole thing. And now their portfolio is built back up again and strong. But we all know what it was like in 2009 trying to work with these lenders, and some of the egregious terms that they would put in their different affidavits, and you could never talk to anybody. And it was a nightmare. Now, eventually they did kind of, like 2 or 3 years later, get kind of their act together and figure it out. But, when the market first shifted and short sales became a thing, it was terrible. Like, it was just a nightmare working with these banks and the bureaucracy and the red tape that you had to go through to even talk to somebody who could make a decision. It was almost impossible.
You just gave me a beautiful segue. I don't know if you knew this or not.
Okay.
Some of the cohesiveness and coherence that came out after some of these egregious short sale affidavits were floated around was what got me started lobbying, because Freddie Mac and Fannie Mae issued an underwriting bulletin that specifically targeted a methodology of short selling that I co-created with others in Ohio, and it went national. It just quickly went national. It was the option contract method. I co-created it with a couple other folks. One of them has since passed away. But when Freddie Mac and Fannie Mae issued that underwriting bulletin, I felt like there was a bullseye on my back. And so didn't know what I was doing, managed to find a lobbyist in Washington, D.C., went to work on it. And then that's when we got the uniform deed restriction language from FHFA. And I helped write that deed restriction language. First time I ever put my fingerprints on something that big. And we got it. So then all the lenders had to start becoming uniform with that. And that was one of the many things that created uniformity coming out of that wave. But it was complete chaos. I swear there were banks that literally hooked up paper shredders to fax machines. And so the fax would come in and go right into the paper shredder.
Right.
Yeah. Just the way of managing their workload. They didn't care.
Right.
We had you had the dual tracking situation where, oh yeah, we'll modify. Oh, we foreclosed on you yesterday.
Mm-hmm.
Yeah.
Right.
So, yeah, there's a lot of things that came out of that. And it was a very eye-opening experience for me to see how Washington, D.C. really worked.
Mm-hmm.
And that was the first time I did it. And then we've had some other successful fights, coming in with a chorus of other people asking for the extension of the Mortgage Debt Forgiveness Act. which that was easy work. Everybody wanted that for a couple more years. And then, then going after the Build Back Better bill, getting the self-directed IRA provisions stripped out of that bill that eventually died in the Senate because it had really lost a lot of blood in the House because of the fight we did there and some others. So, those are some victories that all started because of the short sale chaos. Yeah.
Mhm. Now, Dodd-Frank was a bill that was passed out of the short sale chaos, right? And what's
Yes.
interesting is it goes after these private lenders, but in my mind, it was the institutional lenders that created much of the mess.
Well, okay. So if I disappear someday, you're going to know probably it's because of what I'm about to say.
Uh-oh.
Dodd-Frank was designed to make the too big to fail even bigger.
Mm.
Dodd-Frank is the best redlining, discriminatory policy I've ever seen implemented by a government in the United States of America. Dodd-Frank, by the way it's interpreted and applied, just horribly discriminates against minority and immigrant families and preventing them from buying tradition, going through the banking system to buy homes. Dodd-Frank is a horrible piece of legislation in that respect. Unfortunately, we have one political party that sees that as the pinnacle of a certain former president's administration. And we've had a former chairwoman of the House Financial Services Committee whose mantra has been no changes to Dodd-Frank. And we've been going up against that for years. And we have found 3 members of the Democrat Party who have co-sponsored on this bill, HR 3464. 2 of them are out of Texas. 1 of them is out of Philadelphia, Pennsylvania. We've got rural, we've got urban, I've got agricultural, I've got inner city. They're on the bill. We've got a number of Republicans that are on the bill. One of the original authors chairs a subcommittee on financial services. And if order and common sense could ever come back to the House of Representatives, this bill would actually move to markup through the committee and so on. But Congress is so busy with all these other crises that are half there, half not, that the bill's not been moving. Now we've had the first. I'm going to just give you this. This is for those of you who are political junkies, you're going to love this. The first time we introduced this bill was introduced by Congressman Roger Williams, Republican out of Texas, co-sponsored by Henry Clair, Democrat out of Texas. We had men like Mick Mulvaney, one of the most conservative members of Congress ever. And we had Alan Grayson, one of the most liberal, progressive members of Congress, both on that same bill. We had a congressman out of Chicago, whose name's escaping my brain right now, Congressman Bobby Rush, former treasurer of the Black Panther Party. He came on the bill as a co-sponsor. That bill made a lot of progress the first time around. That session of Congress ended, and then in the next session, word came down, all you Democrats off the bill. The only guy who stood up and said no was Henry Cuellar. Then his friend Vicente Gonzalez came on board. So we've got Vicente Gonzalez and Henry Cuellar, Texas. They have been champions for us for years and years and years. Andy Barr's been there. Tom Emmer's been there. Roger Williams has been there. A number of other key Republican guys have been on this bill over and over again. And so I'm just going to keep rambling and say, listen, if you care about the ability to own real estate and do what you want to do with it, email your member of Congress. Email your member of Congress and ask them to co-sponsor HR 3464. That's all you got to do.
So where exactly now is this bill?
This bill is on the list to go to what they call markup in committee, which means it will be actually brought to the floor in committee, and they will go through it and see if they want to make any changes or additions to it, and then it will go for a vote to come out of committee and then be tacked onto something else and pass through the House. So this bill has made some progress. The other key thing that we got from my home state, Ohio, we've got Senator J.D. Vance, is on the verge of introducing a companion bill of it in the U.S. Senate, along with Senator Britt from Alabama and a couple of other senators. Senator Ted Budd of North Carolina will come on board. And I think Tom Cotton out of Arkansas has indicated favorability on this thing. And so we're just trying to get Senator Vance to stop thinking about becoming a vice presidential candidate and come on, man, get the bill in, because they see his staff saw this bill in a very interesting way. They saw this bill as an anti-hedge fund bill because they said, oh, mom and pops can now sell and hold back paper rather than bulk selling to hedge funds. We like this.
Yeah. So to reiterate, investors or anybody who is, all for home ownership, property rights, the whole thing. It's the Affordable Homeownership Access Act, HR 3464. Call your local representatives, email them, let them know that you support this bill, that you support property rights and the ability to, do seller carryback financing on residential real estate. Reach out, tell them HR 3464.
Yeah. And if you're like, okay, Jeff, that's too much for me to remember and write down, then here's what you do. WatsonInvested.com. WatsonInvested.com. Go there, sign up for the email newsletter. When you get the email newsletter, write back, say, hey, how do I advocate for HR 3464? I'll send you the links. Boom, you're good to go. So WatsonInvested.com, free email newsletter. I've been doing it for a dozen years. I'm starting to get kind of good at it. Working at it. I got an open rate close to 30%, so I'm pretty happy with that. And just, I push out free content that way.
Well, I think what's so important for the listener to understand and see here is that there's a lot of important work being done behind the scenes that just doesn't get that doesn't have the sexy appeal for the general, mainstream press, so that they don't talk about it. So there's a sense that, there is no work getting done. No, there is important work being done, working to amend and revise bills and make them better. And, you have an important voice as a voter with your representative to kind of push this stuff forward.
So the thing, and I so agree with that, because a real estate investor that is not registered to vote is useless. You're useless. You're a bump in the road to us protecting our republic form of government. And I don't have much use for somebody who's not registered to vote, because you've literally checked out, you've given up, you're not acting like you should. If you want to enjoy the benefits of this amazing country, then do something about it. Register to vote, learn who to vote for, learn who to vote against, and get your voice heard.
All right. Really good information, Jeff, on HR 3464. So let's jump to a local issue. We've talked at times, probably with you too, in the past over times. One of the areas I know that Sean and I thought, if we were going to see statewide regulation come down the pipeline with regard to real estate, we thought that it probably would happen in the area of wholesaling. We saw it in our own home state of Arizona a couple of years back. And we thought this is probably where we're going to see more of this. The realtor, real estate agent lobby is I would imagine pretty strong in most places, and we have a new wholesaling law in South Carolina. So why don't you tell us about that law, its purpose, and what it's looking like?
Okay, so I'm just going to shoot straight. Okay. The law is not nearly as bad as everybody panicked and thought it was. I mean, this is okay. Read, people. Learn to read. Don't react. Respond. Before you respond, go read the bill. If you would have read this bill right after it was passed, and you'd have gone down just into the definitions section and looked at the definition of wholesaling as they defined it in South Carolina, you've been like, oh, this isn't that bad. We can live with this. So let me elaborate, but I'm going to have to do that. I'm going to back way up. About 10 years ago, one of my clients, National RIA, said, hey, listen, we see a trend coming and we don't like it. There was a pretty negative article circulated by the Ohio Division of Real Estate among thousands of agents in the state of Ohio. So we get a meeting with the head of the Ohio Division of Real Estate. Turns out we then find that we're on a lot of common ground. We created an educational video where I got to interview the top attorney in the Ohio Division of Real Estate, one of her assistants. And by the way, I still remain friends with this top attorney to this day. And this video has been on YouTube for close to 10 years. It's used as part of real estate education, continuing ed in Ohio. And it talks about the legality of wholesaling. So let's talk about what we should be doing and what we shouldn't be doing. Do not put a property under contract and then act like you own the house and market the house. You're acting like you're a real estate agent. That's a no-no. It's not been allowed. It's been against the law in most states. We can just look at the definition of a real estate broker. What South Carolina says is you can still market a contract on a home that you possess. Now, we're lawyers, and we know that for there to be a contract, you not only have to have a meeting of the minds, but you have to have the intent and capacity to perform. And we know that most wholesalers do not have the intent or capacity to perform. But to try and put that in legislation where people can understand it, well, they can't do it. So what they're now saying, particularly in the state of South Carolina, is listen, if you're an investor or if you're an agent and you're involved with marketing a house for sale that you only have under contract, you're now breaking the law. But if you have a contract on the house, which means for it to be a valid contract, you've got to have the intent and capacity and the ability to perform, i.e. you better have money or access to money, and you better be willing to buy it at that price on that date. If you can't assign it to somebody else, you're allowed to market that contract for purchase or assignment by a third party. But the typical poorly educated, not well-trained wholesaler freaks out because they've heard too many late night infomercial speakers with their slick suits, shiny hair, and flashy watches saying, oh, with the spare change I find in my couch cushions, I can flip houses and become an overnight millionaire. And if there's one thing I want to see go away, it's that whole mantra, that whole teaching concept, because I have been banging the drum for over a decade now of, if you put it under contract, be willing to close on it. Yes, you can try and assign the contract, but you got to market the contract, not the house, which means you've got to say contract for assignment or contract for sale on a 3-2 bungalow in Rochester Hills subdivision. You don't put up pictures. You don't talk about square footage, none of that stuff. You talk about the contract.
What about the address for the property? Can you put that in the advertisement?
No, I've debated that one with multiple regulators. I've debated that with multiple regulators, and every state's a little different. Boy, you can really see the difference between the investigator and the attorney when you start getting into these nitty gritties.
Right.
And so that's a fantastic question. I would tell you that I would not put the address in there. I'd put the street and the locale, but not the actual address, because once again, I'm marketing a contract.
Mm-hmm.
I'm marketing a contract.
Well, and that does make sense. Now let's take it a step further, because there's, what the law allows and what you can actually close on, and those might be two different things.
Oh, yeah.
So in South Carolina, they're a closing attorney state. And I've seen at least one interview with a closing attorney in South Carolina who's basically said, look, I'm not closing if an assignment fee is being paid, because I don't know whether or not their marketing was done appropriately. And so they are at least this attorney is taking the conservative route, saying, I'm just not doing it because I'm not going to get, hauled in and have to basically justify your marketing and your advertising because I closed on this deal where I'm paying an assignment fee. What's your thoughts on that?
That attorney has a very good point. And here's what I would do. I'm not in South Carolina. Don't practice in South Carolina. don't have a guy I can refer you to or a gal I can refer you to in South Carolina, but here's what I would do. I would just create another affidavit, just like a lien affidavit, and I'd have my person collecting the assignment fee sign that affidavit saying that they've read that law, they've complied with that law, they did not advertise the house, they only advertised the contract, and they describe the method and mediums by which they advertise that contract. So that I have them under oath, penalty of perjury, saying this is how I did it.
Right.
That's what I do.
So from a practical standpoint, basically you can't list, because I don't know that there's a category that would allow for it. You can't really list on the MLS anymore like they used to.
Right.
And then that puts you into doing more, social media, private lists, those types of things. And then in that advertising, you can't put the, street address. You could just give a brief description of the property, and then presumably somebody's going to reach out to you, the investor, and say, okay, I'm interested, shoot me the property address. And that should be okay.
That would be okay. If it's in response to that type of marketing. And I'm going to add some more details. I agree with everything you said. But if you're going to use images, make them cartoon images. They cannot be actual pictures of the house.
Mm-hmm.
Make them cartoon images so that, for the guys out there that, oh, well, Jeff, if I don't have an image in my ad, it doesn't do well on Facebook. Okay, then stick a cartoon image in there. Okay, let's just make it happen. But then go ahead and share with them once they've raised their hand privately behind the scenes and said, hey, tell me more about it. Okay, I can share with you a copy of the contract. And you, by looking at the contract, you should be able to deduce where the address is.
Right. Yes.
And then go look at it if you really want to buy that contract.
Mm-hmm.
But I'm going to be like, address is in the contract. Here's the contract.
Right. Oh, that makes sense, because that's what you're marketing. So you basically would redact the provisions of the contract that maybe you don't want a prospective buyer to be aware of.
Right. Price.
Yeah.
The big
price mainly, seller contact information maybe, but you would send that on to the potential buyer, and then they can decide if they want to buy the contract as opposed to, buying the property. Because you're right, the statute does accept out the ability to assign a contract. It does not define that as wholesaling.
Guys, when Andy, Sean, when I read that, I'm on a Friday morning group call, and everybody's panicking and crying about South Carolina outlawing, making wholesaling illegal. And I have got so much stuff on my plate. I finally found 30 minutes. I went and pulled the statute. I'm reading through the definitions. I got to definition number 44 where they define wholesaling, and I go, what are you crying about? It's what I've been teaching for 10 plus years. So anyhow, but it just illustrates to me the point of there is a legal way to do this business, but it requires much more deliberate thought. And I'm thrilled. If most of the wholesalers are going away, I'm thrilled.
Well, and if that's where the market's going, or maybe if that's where regulation goes, seems like the industry might be crying for, and maybe it has one. I'm speaking out of a little ignorance here, but I'm kind of assuming it doesn't. But the market would almost be crying for a really nice technology or software that helps to appropriately market contracts, right?
Well, there are some individuals, I think you're acquainted with most of them. They only approach me just tangentially. I'm not going to mention any names, but because I don't want to omit a name, but I think you're aware of most of them. Some of them are your market. They wanted to create some sort of governance board for wholesalers. They were viciously attacked by other wholesalers and investors. Viciously, just torn apart. Because, folks, wholesaling is the wild, unregulated west of the real estate industry. And we had an economic cycle that was lasted longer than it should have. So think about that. That just saw this whole business industry of wholesaling spring up. coming out of the short sale world, did you ever think you would see wholesalers that were literally closing 3 and 4 deals a day? That they build these huge, massive operations? No. But they have, and a lot of them are struggling now, and I'm fine with that. So that's that's where we are.
So
Yeah.
What's interesting though about this law is, as you point out, there is a way to maneuver a wholesale transaction through and to close, assuming you can convince a closing attorney to close on it. But this law actually would do away with, because I don't know a way around for double escrows or for novations. I don't see a way around the law for those two types of transactions.
Yeah. Now, but I'm gonna go back to this. Okay. I want to make sure you and I are on the same page. I have never read a statute that prohibited a person who owns a property from selling it by themselves. I've never seen a statute out there. I've never seen anything that says, oh, you can't FSBO. And so my response is, the worst case scenario that's ever out there is, okay, I advertise to buy hoarder houses. I buy the hoarder house. I actually close. My crew goes in with 3 40-yard dumpsters. We fill them up. We try and deodorize the house a little bit, and then we put it back on the market. We've owned it. There's nothing saying I can't do that.
Right. You can do that, but let's say you have it under contract and you want a double escrow because maybe you want that end, the end buyer with financing. Let's say you want to do a novation, right? Where you want the end buyer to be able to enter into a contract directly with the seller. But the way I read this South Carolina law is, unless you have some form of ownership of the property, not just a contract interest, but some form, you cannot reference the property anywhere in any advertising. So how would you advertise a double escrow or advertise the property to double escrow?
You can't.
Right.
You're right.
Can't.
You're right.
Yes.
And you can't advertise it. Now, could you do it? Could you arrange this in a private conversation? I don't know. I don't want to get there.
Yeah, I'm not
I don't
sure
want to get
how.
there.
And would somebody close that? Because it's like, well, how did they even find out about your contract if you're not? I mean, it's one thing to market the contract.
Yeah.
I guess you could say, well, I marketed the contract and instead of assigning it, we decided to double escrow. I mean, I guess that would be, but on the flip side, it just seems like, how would you do it? Because you don't have any, ownership interest in the property at that point.
Correct. And those are things that I've tried to beat into the heads of my wholesaler clients, and they, some of them learn and some of them just go away. They don't want to pay me to learn. They just say, I'm not going to get caught. And when they get caught, I'm like, nope, we're not talking. And there's a lot more regulatory enforcement out there. And some of that regulatory enforcement is really good, and I welcome it. But I had one the other day where, a jealous real estate agent turned in a wholesaling company for, quote, breaking the law in the state of Ohio. The investigator took a look at it, sent it to my client. My client freaks out and panics. I look at what the issue is, and I go to the 3rd page of the marketing material on this particular property. And there it is in nice, obvious language. One or more owners of the company selling this house is a licensed real estate agent in the state of Ohio. I call up the investigator and I go, did you happen to read that? Was it something with the font that you didn't like? Do you need it bigger? Does it need to be on page 1 instead of page 3? He's like, I'm sorry, I didn't see it. Click. Done.
Yeah. So Jeff, we got a few minutes left, and I asked this question and know there's great danger in asking Jeff Watson his opinion on a big law, but I can't help myself. I want to hear what you have to say. The Corporate Transparency Act has been a big topic on our show. We covered it with an attorney out of Florida, Natalia, who kind of went through the details of the Corporate Transparency Act. We've since had a show about its constitutionality, given that there was a federal court ruling out of Alabama on that. So we've had quite a few discussions about it. I know you're pretty tapped in. I've seen you make. I've heard your opinion briefly about it online, but I wanted to ask you about it. What are your thoughts? Does it survive constitutional muster?
No,
You think it's going to go down in the long run?
I think it will eventually go down, but I don't know when. And by the way, I think the same analysis can be applied to the FTC ruling on non-competes.
Mm.
I don't see where the administrative body, the executive branch of the federal government, has the ability to step over the 10th Amendment. I just don't see that. But let's go back to the CTA. That's regarding non-competes. When we go back to the CTA, that was passed by legislation. I think the Alabama court, the federal court in Northern District of Alabama, got it right.
Hmm.
And then they did that typical thing. They backpedal and they go, yeah, but our ruling only applies to the plaintiffs of this case. And so I don't know if it's a vampire or a zombie or a hybrid between the two, but I look at the Corporate Transparency Act as this thing that should be dead that needs a few more silver bullets shot through it. Kind of like the mortgage or the eviction moratorium coming out of the CDC. It's the same thing. It's unconstitutional. It shouldn't be going there. Yes, somebody's gonna argue, well, Jeff, the eviction moratorium was originally passed by Congress and then administratively extended. Okay, fine. But the problem is real estate investors are not the problem when it comes to human trafficking, money laundering, and drug abuse and drug sales. We're not the problem. Mm-hmm. We don't move huge amounts of currency around. But they're treating us as if we are part of the problem, as if we are the worst of society. And it really comes down to the government has unquenchable appetite for two things: money and control. And to do that, they need information. And the more information they have and the more money they get, the more control that they can have. And that's what they're trying to do. And I'm gonna go all the way out on the limb, guys. You may just edit this out, whatever. But it's a reversal of the culture of what this country was founded upon. We have now taken and put government over the top of God. In government we trust rather than in God we trust. That's what we're seeing. Now, I think the Corporate Transparency Act is a bad piece of legislation. I'm telling all of my clients that if you had an entity that existed before 2024, don't even think of reporting until October of this year, but do not wait until December. You got to find that time between the beginning of October and Thanksgiving. Put it in then. If you've, like me, and you formed a new entity or two this year, pay attention to that 90-day clock.
So let's just assume, because you're plugged in. So let's assume that we get the court ruling that we should get. I anticipate getting from the United States Supreme Court at some point in time that says, hey, you cannot, because the biggest issue, right, is the trigger for the reporting is the filing of incorporation documents in a state. That's the trigger.
The approval of the filing.
The approval of the filing. Yes. So you file and it's approved. It doesn't matter if you engage in commerce. It doesn't matter if you open a bank account, get an EIN, none of that. That's the trigger. And I think that's where the court was hung up on, is like, how can that be the trigger? That's state, specific state law. What gives you the right to regulate that? Do you think, though, that if the U.S. Supreme Court were to strike it, that there is support in Congress to rewrite it and make it more narrowly tailored to alleviate that issue?
So as it stands today, you got to remember what Congress looked like when that bill was passed, because that bill was in part of a huge defense appropriations bill that got shoved through when one party controlled the White House, the House of Representatives, and the U.S. Senate. That is no longer the case. And I've had two friends of mine that sit on the right committee in the House of Representatives that said to me, that bill would not survive a day in our committee today. And friend of mine, big supporter of the Affordable Homeownership Access Act, HR 3464. He looked at me and he goes, "We couldn't stop it." He says, "We were in the minority. We couldn't stop it."
Yeah. Although I do know that there was some bipartisan support for
because they stuck it inside of this huge defense appropriations bill, and who's going to want to vote against paying our soldiers?
Right. Exactly. Yeah.
The omnibus.
That's the optics, the game that they play on us.
Right.
Yeah.
Yeah.
Well, Jeff, it's been really good having you. Maybe if this goes to the Supreme Court, we'll do a live stream of the oral arguments on the corporate.
That would be interesting.
That'd be kind of fun, huh?
That would be a lot of it. That would be very interesting. I have begged some of my clients to just cover the cost of me literally copying, pasting the Alabama pleadings and trying it here in Ohio. And I can't get them to, they don't want to do it.
Yeah.
And it's so frustrating.
Well, Jeff, thanks so much for being with us. Tell our listeners how they can find and connect with you.
Sure. The best way to find me, the best way to connect with me is go to watsoninvested.com, watsoninvested.com. Watson Invested is all one word, watsoninvested.com. It's a blog that you can read a bunch of free articles I've got up there. You can click on some links and go watch all these videos about wholesaling that I did with the top regulators in the state of Ohio that's influenced dozens of other states in the way they think because of the influence that the people in Ohio have with those other states. And you can just get my free email newsletter. And then, you can either read it and take action on it, or it's worth what you pay for it, man. It's free.
All right, everybody. That's Jeff Watson. Jeff, let's do this again sometime soon.
That would be fun. Looking forward to it.
All right. We'll see you next time, Jeff. With that,
Peace.
everybody, that is our show. Make sure to join us at 2 p.m. for the collective and next week for the show. We'll see you then.
Have a good day, everyone.